Welcome to the deep dive. We take complex information and boil it down for you. Today we're tackling Chapter 2100 of the Manual of Patent Examining Procedure, the MPEP, specifically Section 2145. It's titled Consideration of Applicants' Rebuttal Arguments and Evidence. Basically, this is about what you do when the Patent Office, the USPTO, thinks your invention might be obvious.
Exactly. This is a really pivotal moment in getting a patent. Section 2145 kicks in right after the USPTO says, okay, we think we found prior art showing this invention might be obvious. That's called establishing a prima facie case.
Prima facie, so like their initial assessment, their first pass.
That's a good way to put it. It's their initial argument backed by evidence saying, hey, based on what we see, this looks obvious.
Okay, so they've put their cards on the table. What's the applicant's move then?
Well, this is where Section 2145 really comes alive. The ball is now firmly in the applicant's court. The burden shifts, you see. It's up to the applicant to argue against that obviousness finding and, crucially, to provide evidence.
Evidence. So what kind of arguments or evidence are we talking about here? What tools do they have?
There are several routes. A very common one is submitting what's called objective evidence. Often this comes in the form of sworn statements, declarations under Rule 37 CFR 1.132. These can bring in things like real-world data, maybe test results, expert opinions, stuff like that.
Formal statements with backup data. Makes sense. Anything else?
Yeah, applicants can also point to arguments already within their patent application, in the detailed description, the specification, maybe highlighting things that weren't fully appreciated before, unique features. And they might submit other things during the process too, maybe technical articles, data showing results that were, well, unexpected.
So a few options there, but I feel like I've heard that just saying my invention is great doesn't really cut it with examiners.
You are absolutely right, and that's a huge point in Section 2145. Attorney arguments alone, usually not enough. The MPEP is pretty clear. While the examiner has to consider the arguments, the law generally demands substantive factual evidence to back them up. You need proof.
Right. Words are good, proof is better. So the applicant gathers their evidence, writes their arguments. What does the examiner do then? Just read it and say yes or no?
Oh, not at all. The examiner has a legal obligation, actually, to consider everything the applicant submits in rebuttal. They can't just ignore it. They have to weigh it carefully against their initial prima facie case.
So they really have to engage with the rebuttal?
Yes, definitely. They need to perform a reasoned analysis and decide if the applicant's evidence and arguments overcome the initial finding of obviousness. It's a critical balancing act.
Okay, so wrapping up this initial part, USPTO flags potential obviousness, applicant pushes back with arguments and, importantly, evidence, and the examiner weighs it all. So where should we really focus our attention as we dive deeper into this section? What are the key parts?
Good question. I think we should focus on two main things. First, the specific types of rebuttal evidence that examiners really have to pay attention to. These are often called secondary considerations. And second, the court cases, the legal precedents that have really shaped how this whole process works.
Okay, secondary considerations. Sounds important. What falls under that umbrella?
Yes, secondary considerations. They're also known as objective evidence of non-obviousness, and they can be really powerful. These are sort of real-world clues suggesting an invention wasn't obvious, even if on paper it might seem like it was just combining known things.
Real-world clues, like what? Give me some examples.
Sure. The MPEP lists several key ones examiners must consider. Commercial success is a big one. If your invention becomes a bestseller, that suggests it met a need others missed, right?
Yeah, that makes sense. If it was so obvious, why wasn't it already out there and successful?
Exactly. Another is long felt but unmet need. Was there a problem everyone knew about, people were trying to solve it, but couldn't until this invention came along?
Okay, also logical. What else?
Failure of others. Did competitors or other smart people try to do something similar and fail? That suggests the path wasn't obvious. Then there are unexpected results. Did the invention do something surprising or work way better than anyone would have predicted based on the prior art?
Unexpectedly good results. Yeah, that sounds like strong evidence.
It can be very strong. And finally, topping by competitors. If others immediately start trying to copy your invention once it's out, it implies they saw its value and recognized it as something new and desirable.
That's a good list. Commercial success, long felt need, failure of others, unexpected results, copying. Got it. Now, you mentioned something interesting earlier about showing great results in just one version being enough sometimes.
Right. That's a nuance worth exploring. The MPEP points out that, yes, sometimes showing superior performance in just one embodiment, one specific version covered by your claims, can be sufficient. But there's a catch, of course.
Always a catch.
Well, the results shown in that one version need to logically extend across the entire scope of the claims. You need to argue convincingly that the reason for the better performance isn't just tied to that one specific example, but is inherent to the broader invention claimed.
Okay, so the benefit has to reasonably apply to everything you're trying to patent, not just a corner case.
Precisely. And that ties into another critical concept, the nexus.
Nexus. Sounds like legal jargon. What does that mean here?
It essentially means link or connection. The applicant must show a nexus, a direct link, between the evidence they're presenting, say, the commercial success, and the specific features of the claimed invention. If the product is selling well because of great marketing, or maybe a feature that isn't even part of the patent claim, then that commercial success evidence loses its punch for proving non-obviousness.
I see. So the success has to be because of the inventive part you're claiming, not something else. Makes sense. Okay, let's shift to the legal side. You mentioned case law is really important here.
Absolutely fundamental. Patent law evolves through court decisions, and Section 2145 directly reflects that. The rules aren't just made up by the USPTO, they're guided by how courts have interpreted the law.
And you flagged Dillon and Sony earlier. Why are they key?
Well, Dillon and Sony really hammered home the point that examiners must consider all the rebuttal evidence.
Yeah.
All of it. And crucially, they stressed that this consideration has to happen within the bigger framework for obviousness established by the Supreme Court in Graham v. John Deere.
Graham, right. That's the big one for obviousness, isn't it? The framework everyone uses.
That's the one. It looks at the prior art, the differences from the invention, the skill level in the field. What Dillon and Sony help clarify is that those secondary considerations, the applicant's rebuttal evidence, they aren't just tacked on at the end. They have to be part of that whole Graham analysis from the get-go.
So it's not like step one, look at prior art, step two, maybe glance at rebuttal evidence. It's all mixed together.
Exactly. It's a total picture analysis. And the MPEP even points to other cases to illustrate this. How about Sullivan? What did that case show?
Sullivan, yeah. My understanding is the review board, the PTB, messed up by basically ignoring some expert statements that supported unexpected results for, I think it was an antibody fragment. The court said, nope, you got to consider that evidence.
That's a great summary. Sullivan is a clear signal that credible evidence, especially expert evidence showing something unexpected or advantageous about the invention, cannot just be waved away. It demands consideration.
Okay. And the other case mentioned was hearing components v. Shore.
Right. Hearing components is interesting because it went the other way. The court upheld a finding that the invention was not obvious. And a big reason why was the strong evidence of secondary considerations the patent owner presented. Plus, crucially, they show that clear nexus we talked about.
The link between the evidence and the invention itself.
Yes. They successfully tied things like commercial success directly to the patented features of their product. It shows how powerful that objective evidence can be when presented properly.
So these cases really drive home, consider all the evidence, weigh it properly, especially that real-world objective stuff. Now back to something you touched on earlier, the limits of just arguing.
Yes, let's be clear on that. Section 2145 states pretty directly.
Yeah.
Persuasive attorney arguments are fine, they help frame things, but they are not a substitute for facts, for evidence. You can argue eloquently all day long, but if the examiner has solid prior art showing obviousness, you need factual evidence to push back effectively.
No amount of smooth talking replaces cold, hard data, essentially.
You got it. And another related point the MPEP clarifies is about discovering new uses for old things.
Right. Finding out something already known has some new amazing benefit you didn't realize before. Does that make it patentable?
Generally, no. Discovering a latent property, a previously unknown benefit of an old compound or device, doesn't automatically make the old thing patentable. Obviousness is judged based on what was known at the time of invention. Finding a new use later doesn't change what was obvious back then.
Okay, that's an important distinction. What about how applicants need to counter the specific prior art the examiner uses?
Yes. This is key. Rebuttal arguments need to tackle the combination of references the examiner puts forward. Examiners often combine 2, 3, maybe more pieces of prior art to argue obviousness.
So you can't just attack each piece individually, like saying reference A doesn't show my invention, reference B doesn't either.
That's usually not enough. You need to explain why combining them, in the way the examiner suggests, would not have been obvious to someone skilled in the field at that time. Address the combination, the reasoning behind putting them together.
Attack the glue holding the references together, not just the bricks themselves.
That's a great analogy. And related to that, simply complaining about the number of references or how old they are, or arguing they couldn't physically be put together, those arguments usually don't carry much weight on their own.
Unless there's a specific legal reason why those things matter?
Exactly. You need to explain why the age, or the number, or the incompatibility actually makes the combination non-obvious in a legally relevant way. Just pointing it out isn't enough.
Okay, so the rebuttal needs to be focused, evidence-based, and tackle the examiner's core reasoning. What's the standard the examiner uses to judge all this? How do they make the final call?
The standard they apply is the preponderance of the evidence.
Preponderance. So, like, more likely than not. Tipping the scales.
That's exactly it. It's a balancing test. Does the evidence supporting non-obviousness, including the applicant's rebuttal, outweigh the evidence supporting obviousness, the examiner's prima facie case? It's not beyond a reasonable doubt like in criminal law. It's just which side has slightly more convincing evidence.
And they can't just dismiss the applicant's evidence lightly.
Correct. The MPEP mandates that rebuttal evidence shouldn't be dismissed unless it clearly lacks weight, relevance, or that crucial nexus to the claims. There must be a fair, reasoned analysis documented in the record.
Okay, that paints a pretty clear picture. So wrapping this all up, what's the main takeaway for an applicant facing an obviousness rejection based on Section 2145?
The big takeaway is you have a right and an opportunity to fight back against an obviousness rejection with arguments and evidence. But, and this is the critical part, your rebuttal needs to be grounded in facts, directly tied to your claimed invention, and address the examiner's reasoning. Understanding those secondary considerations, knowing the importance of the nexus, and being aware of the case law, that's really vital for building a strong response.
Excellent. So, a final thought for you, our listener, to mull over. Think about this interplay. The USPTO makes its initial case, the applicant responds with evidence showing real-world impact or unexpected results. Where does true innovation really shine through in this process? Is it just the initial idea, or is it also demonstrated in the ability to prove its non-obviousness against challenges? Something to consider. That brings us to the end of this deep dive into MPEP Section 2145. Thanks for joining us.
Special thanks to Mike Shepard, the creative director who organized and inspired this educational project. His work makes this detailed MPCP audio series possible.
Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions.
It's provided for general educational and informational purposes only, and is not legal advice or a substitute for formal instruction.
For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.